the Crown had closed its case, having called 19 witnesses, including a DNA expert from abroad. And today saw the closing of the case from both defendants. And what will happen tomorrow is that the first defendant, Milton Maza, will sort of sit out a bit because he did not call any witness in the case. And so the second defendant, López Avila, will give a closing submission to the court through his attorney, Mr. Leroy Banner. And then the Crown will respond by putting forward submissions in which it will assert that it has proven its case beyond a reasonable doubt that in fact the first and second defendants did commit the offense charged. The offense is charged. And then I will close responding to what the Crown has said, putting my case that in fact the Crown has not met the threshold. The Crown had not adduced evidence sufficiently enough to prove their case beyond a reasonable doubt. I am not concerned that the Crown called a long list of witnesses because at the end of the day, the defendants had nothing to prove. The burden of proving the case relied on the Crown throughout, and the standard of that burden is proof beyond a reasonable doubt, so that the Crown had the duty to prove to the court its case. Our clients could have remained silent throughout and need not have said anything at the end of the case, and it would still have been upon the Crown to prove its case. So I am not disturbed that we only had 3 witnesses in total, including the 2 defendants themselves.
The 2 defendants took the stands today. Maza from the dock and López from the witness box. Forgive my ignorance, but during the trial, did the judge accept the caution statement as evidence?
Yes. We had a trial within a trial, a voir dire. And in that voir dire, His Lordship, the judge, had ruled that the caution statement that was elicited from Milton Maza was in fact given freely and voluntarily. Therefore, in my submission, I will be making representations that even though the judge ruled the caution statement to have been admissible because it was voluntarily given, he should now consider the other limb, whether or not it is in fact true. So, did a caution statement emanate from my client? Yes. But was the content of it true? That is the other question that the judge and the court has to determine.